Can you hear me?
Yes.
Okay. Pat, can you hear me?
Yes, I can.
What's happening? You're having difficulty?
Yes, there'll be, wait till you hear from Ms. Davis.
Okay.
Okay, Mr. Chairman. We can
Okay.
start with the preamble.
All right, in compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1796, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile versions and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Mr. Jacobson?
Mr. Chairman, this is Dan Jacobson from the Law Department. Preliminary issues, the live stream. Can we verify that the live stream is on and functioning?
Yes, it is.
Thank you. Mr. Chairman, as the Law Department has done since these public meetings have gone virtual and or hybrid, law states its objection to the use of the chat function. Thank you.
Okay, thank you. Ms. Davis?
Mr. Bradley,
Here,
Mr. Maskey,
Here.
Mr. Dink,
Here.
Mr. Gallagher.
Here.
We have a quorum.
Okay, we'll call the first docket A 402-23, 6501 Barberton Avenue.
Application and fees are in order. Notice of violation is an elevator issued on December 14th of 2023. Appeal was received December 15th of 2023. The appellant is requesting for 2 years to abate the violations. Present for today's hearing, Tom Vanover, Chief Building Official, Dan Jacobson, Law. Will the appellant or his or her attorney and or representative please state your name and your capacity to the property?
Greetings, I am Jordan Morales, and I am the owner of Stockyard Studios, 6501 Barberton Avenue.
Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir.
Okay, go ahead and proceed. Let us know what the plans are.
Okay, thank you for your time today, sir. So I've recently taken over the Stockyard building in 2023 of March. I myself am a local Clevelander who is just embarking on a new journey to develop and enrich my community. With that being said, the 100,000 square foot building is a process in which is going to take me quite some time. Currently, I'm doing everything in my power to secure that those violations are deterred. I've put up wooden panels in each of the elevator shafts to just negate any accidental activities. And yeah, I don't, this is my first time in one of these, I guess, hearings, but I guess my case is really just, on my behalf, I'm doing everything I can to put this property on the radar of local developers and developers abroad to really transform this space into a functioning community art space. And so my request again is 2 years, in which I am hoping to proceed with federal granting, state granting, and private funding to rehabilitate this space in which I see opportunity.
Okay, so what I'm seeing before us is a notice of violation of elevator.
Yes, sir.
What are the plans on that?
So like I had stated, currently my actions have been to put up wooden panels in front of each of the elevator door shafts to eliminate any accidental concerns of, I don't know, really the violation I would imagine is to make sure that nobody falls down the elevator shaft or any of that activity. But to be frank, there's really no human activity in my building. Currently, it just serves as a storage facility where I store my motorcycle and some offshoot furniture. But that's my action has been thus far to at least address the violation that is in place.
Okay, are there actual elevators in the shafts?
Yes, sir.
Okay, and they're not operational?
No, sir.
Okay, all right, let's go over to Mr. Vanover and see where we're at here.
Mr. Chairman, to the appellant, how many stories is this building?
Sir, the original building is 4 stories and the addition is 3 stories.
And Mr. Chairman, Mr. Morales, this is the elevator, there's elevators in both?
Yes, sir.
How many elevators are there total through the
2,
chair?
sir.
And through the chair, neither of those are working?
Correct.
So, Mr. Chairman, this, I mean, there's, you know, the law is clear that, you know, if the elevator, if there is an elevator, it has to work. Now, whether or not, you know, it has to function properly. While I respect what the appellant is attempting to do with this building, and it is a large building that's could use some attention. At the same time, we object to 2 years. Especially with 2 years, 2 years to obtain funding, because that 2 years may not happen. We all know how funding works. So we don't object to some time, but it's going to need to be considerably better planned. Simply putting, you know, plywood over the shafts, it's not necessarily the solution and may actually create a bigger problem if there is a fire event in the building. So we're going to need a better plan before a decision could be made, Mr. Chairman.
Okay, Mr. Morales, I'm assuming you're planning on using the elevators at some point, is that correct?
No time soon, Your Honor. But yes, eventually, when the building is functioning, correct. Yes, that would be, that is a part of the phase to, you know, reach the higher stairs is to activate the elevator.
Okay. All right, so,
Mr. Chairman, we would ask that any extension of time include a consultation with an elevator contractor to get a real scope of work and bids on what it would take to correct them. Also, what it would take to properly temporarily put them out of service, which typically includes removing the power from them, bringing the elevators to the bottom floor, and then using a non-combustible partition to block them off for a period of time. Not putting them out of service, which would require the removal of the elevator, but a temporary, you know, some temporary solution to where they're made safe, and while they're waiting on getting them fixed.
Might I add, I have, you know, explored those opportunities in regards to decommissioning and bringing the elevators up to speed. And just currently financially, you know, the $13,000 and the $23,000 that was expressed to get these in some type of functioning form is just personally is just not I don't have those resources at this moment, but I just wanted to gesture that to let you guys know that I am doing everything in my power. And as a young entrepreneur in the city of Cleveland, trying to work on a major development to enrich my community, I would just ask for some mercy and some grace within this process of, getting this building into, a form that is, safe and functioning.
Okay, so are you working with an engineer or an architect on any of this yet?
Yeah, the architecture firm is Jera Inc., Jera Inc. I'm also, pursuing personal education within the city's real estate diversity initiative to connect furthermore with more architects and contractors. And so again, Your Honor, I am doing everything in my power to advance the situation. I'm sure you guys can see this building has been on docket as far as I can see since 2016. I just purchased the building in 2023. So for the past, I don't know, 5-6 years, it's been neglected, and you guys have been after the previous owner in which I purchased the building from. But, I would have to say that I'm making much more progress over the last year than has been made in probably the last 2 decades within that building. It's been a process just clearing out the building from all of the hoarding stuff that was in there. So, again, I just plead my case for, some type of extension. I understand maybe the 2 years might not be feasible for the board, but, I just ask for some type of grace.
Okay, so
So, Mr. Chairman.
Go ahead. Go ahead, Mr. Vanderwerf.
So, yeah, Mr. Chairman, to Mr. Morales, although, $23,000 is a lot of money when you don't have it. And we understand that, but comparatively speaking, those are, for elevator work in general, experience is thought that's really not insurmountable. What is important is that the funding, the funding be acquired and be focused on these, on correcting the elevators, understanding that you've got funding that has to go to other places as well. But Mr. Chairman, again, we don't object to more time with, we would not object to 180 days with the understanding that provisions are made to assure that the elevators are made safe in that time. And then a real plan on getting them, if not both at the same time, one at a time, corrected and functioning.
Okay, Mr. Morales, so I think the focus here has got to be on those elevators and getting them, safe, which if the least that you have to do, okay, is to get them so that they go down to the bottom, okay, and you should know the requirements for the elevator. I know the city hadn't, your architect could probably tell you, but your city has have people there that are at least they did that know all about the elevators and what needs to be done, and so you're going to have to find that out and to get them down to the bottom and then put as Mr. Vanover said, something non-combustible over those openings wherever they are, and also disconnect. Unless you can just, if that's the money and you can get that money raised to get them working and operational, then all the better. But I think we're going to do is going to go ahead and give you the 180 days to get the elevators taken care of, and then you can move on with the plan from there to whatever you're going to do with the rest of the building.
Mr. Chair.
Yes.
Mr. Chairman, I would ask that the resolution include, for both of our purposes, as an order to the appellate and an order to the city, to include a site inspection with the elevator bureau to define what made safe is, short of decommissioning.
Okay, so that should be almost immediate. You need to get that person in from the city to assess that, and they can tell you what exactly needs to be done. So we would ask you to go ahead and do that first. Say I would get somebody over there as feasibly, at least within 60 days to, probably within 30 days, to make an assessment on what needs to be done with the elevators correctly, what the proper procedure is, and then 180 days to complete and take care of the violation. Motion?
Mr. Chairman, we need
Yes, you
dates
need some
certain.
dates. Okay.
Yeah,
June 21st is 30 days, 2024, to have it inspected. And by then, and September 21st, November 21st, 180 days, 2024, to abate the violation. Motion?
So moved.
Might I,
Motion by Mr. Bradley,
Second.
second by Mr. Maschke.
Mr. Bradley,
Yes.
Mr. Maschke,
Yes.
may I,
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out to you within 2 weeks, Mr. Morales.
might I add a few things, gentlemen?
Yes, go ahead.
One, the elevators are on the first floor. I don't know if that alters anything. Secondly, the building is largely on the verge of being condemned, right? So I've had it overviewed by multiple contractors, and it's a $7 million. I mean, it's a 7-figure project, and so it's quite disappointing to recognize that me as a young entrepreneur here in the city of Cleveland, doing my best foot forward, asking for in my opinion, a small amount of time compared to what the city has been after the previous owner.
Mr. Chairman, to the appellant, I don't mean to cut you off, sir, but you keep going on this fact that you're a young entrepreneur, and we appreciate that. Have you done any other development projects in the city?
That's my first one, sir.
This is quite a big one to chew off on the first go.
Yes, I
And
understand.
I think we've given you some leeway to give you time to get the elevator taken care of. If the building is as bad as you think, I'm likely to reopen the case and just remand the building back to the city, and you can work directly with the city with no time to do the work.
How would that work out, sir?
You would report to the building department and they would tell you what you would need to do. But my concern is you don't have any funds. You have a 7-figure plus project and you've never done this before.
This is
People
correct.
struggle with just doing homes. This is a major project.
This is correct. Yeah, I'm very ambitious in this project, sir, and I see an opportunity within the Stockyard neighborhood. And again, I am doing everything I can
We
to.
appreciate the energy, but if you don't have any funds and you're trying to get funds in a short period of time, it's not very likely you're going to get all the funds needed to do this project properly, and the neighborhood's going to suffer even more.
Well, I, with all due respect, sir, I've already cleaned up the neighborhood, and that small pocket has greatly appreciated my presence compared to what was in that building. So I beg to differ that I'm actually adding value to that neighborhood. It just takes time. With anything, takes time. And, with all due respect, I understand this is a large bite off for me, but with anything, I think that me personally, I have to submerge myself in it to learn and to figure out those problem solutions. And so I guess, again, I understand exactly where you're coming from. I know the law is the law. I just, no more said. I understand.
Okay, let me wrap this up for you, Mr. Morales. What we're talking about is a violation for the elevators, okay? The rest of the building, that hasn't been cited yet, okay? But what we're dealing with right now is getting those elevators and focusing in on them. So your bigger plan, it's still out there. You're fine. We're talking about the immediate problem, which is these elevators, and we're giving you that time to get them fixed and get them functional. And we've given you the dates to go ahead and do that. So that's what we're talking about here. All right?
Very well.
Okay. All right. Notice will be sent out within 2 weeks. Thank you. All right. Next docket is, building docket A 2174 West 103rd Street. My understanding is that has been withdrawn.
That is correct.
Okay, we'll move on to the next docket, building docket A 424 7000 Central Avenue.
Application and fees are in order. This is a notice of violation is hazardous conditions and exterior maintenance. Issued on December 6th of 2023 and January 11th of 2024. Present for the hearing. Appeal was received January 5th, 2024. Present for the hearing, Tom Vanover, Chief Building Official. Dan Jacobson, Law. With the appellant or his or her representative, please state your name for the record. Mr. Chairman, it does not look like anyone from Crystal's Lights Cleveland LLC
Okay,
is
Um,
present.
okay. Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Okay, thank you. Mr. Vanover.
Mr. Chairman, there was 2 violation notices issued on this property. I think the photographs say quite a bit. It was cited for exterior maintenance and hazardous condition. The property has since been boarded, but that doesn't mitigate the hazardous condition. That this in the city was, excuse me, the property's been boarded by the city. We would ask that you deny any more time, uphold the notices properly issued, and remand it back to the Department of Building and Housing.
Motion is in order to deny more time, remand the property to Division of Building and Housing for any further action. Motion?
So moved. Second.
Moved by Mr. Denk, second by Mr. Maschke.
Mr. Bradley,
Yeah, yes,
Mr. Maschke,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice will be sent out within 2 weeks. Okay, next docket are 2 building dockets we're going to call up together. Docket A 10-24, 2517 East 57th Street, and building docket A 51-24, 2517 East 57th Street.
Application and fees are in order. The notices of violations are as follows. Exterior maintenance, hazardous conditions, vacate, and condemnation of the main structure. Issued December 13th of 2023 and March 4th of 2024, requesting for 180 days to complete abatement of the violations. Present for today's hearing, Chief Building Official Tom Vanover, Dan Jacobson Law. Will the owner or his or her representative please state your name for the record?
Ricky Jones.
Okay, Mr. Jones, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, go ahead and let us know what the plans are.
The plans is I've been getting quotes. getting close from, to do the porch, or the exterior porch, and we went to pull, a permit. And then, the, Inspector Shockley condemned the building.
Okay,
We couldn't pull a permit. But since then, I also cleaned up outside, and it was a wire, loose wire hanging out on the front porch that we since then corrected.
okay. So, you say you're unable to pull the permit because it's condemned.
Yeah, it wasn't condemned, but now it's condemned, but I was confused on how it got condemned because I already, never, me and Inspector Shockley never walked an entire building. I never,
Okay, well, maybe we need some clarification. I'll go over to Mr. Vanover.
So, Mr. Chairman, to the appellate, Inspector Shockley's involvement, and he is with our senior initiative program, and there is a senior initiative case on this property. And so, Mr. Chairman, to Mr. Jones, what is, I would ask, what is, Mr. Jones, your involvement with the property?
Mr. Jones,
yes.
you were being asked what your involvement is with the property.
Can you hear me?
Okay, you're the owner. So you break up every now and then, but, go ahead.
So,
Okay.
Mr. Chairman, this property is owned by RDJ Group LLC.
So are you a representative of that, Mr. Jones?
Yes, I'm the owner of RDJ Group LLC.
Okay,
And Mr. Chairman, who is the senior resident that's being served in this property?
Mr. Jones?
William Vaughn. She was in the building when I bought the building. She's been in the building for years. The problem with the tenant, I served her a 3-day notice already. But she's been in the building I haven't started the interior work because she has like 100 cats. All the cats in the neighborhood go through her living room window. So she won't even let me in her unit. So the pictures that we have on the screen is her unit. So when I bought the building, sight unseen. And if you go, Inspector Shockley, if he's present, he'll tell you that all the cats from the neighborhood just jump in her window and they live in her unit.
So, Mr. Chairman, there are multiple notices of violation on this property. And I would like to address them individually.
Okay,
I would ask that, bear with me, I will get the numbers. I would ask that violation notice for the order to vacate, which is violation notice V24006746, be upheld as properly issued, and that it be demanded and remanded back, denied and remanded back to the Department of Building and Housing. Because the conditions of the property are not suitable for habitation. And then we, as far as the notice of condemnation, we don't object to more time to correct the condemnation. I'm not sure if that's the ask. But the condition of the property on the interior and the exterior, indicate that it is condemnable and that considerable amount of work needs to be undertaken.
okay. So so that violation that you had quoted, we can uphold the violation as properly issued and remand that portion back to the city property to Division of Building and Housing for any further action. As far as the condemnation, as we're going to go back to Mr. Jones, how much time do you need to abate to bring that out of condemnation?
Well, a couple of things with the combination. So my question, if they never walked the other 3 units, and their other 3 units is water, water, and the violation said that the all 3 other units once. So he never walked the other units. So I just for the exterior. If you make the building condemned, I have to get drawings, and it's not condemned. It's running water, it's heat everywhere, and the lights have been on. But the exterior stuff I can get done by the end of August 31st. And
Did you
I already
get some of that,
served
Mr. Vanover?
the 3-day notice.
So, Mr. Chairman, as a condemned structure, the requirement is that they provide, that a floor plan is provided, information and evidence showing what work is going to take place, and photographs. We do not require architects or sealed plans, as the code does not, but we will need a floor plan, and that can be drawn, providing that it's architectural quality by the owner. There will be a contractor required because it's corporately owned. But the conditions of the property that we've.
Go ahead.
Commercial
Mr. Vanover. Finish up, Mr. Vanover.
So, Mr. Chairman, the condition of the property that we had seen and have inspected indicate, and the board can rule, it indicates that it's condemnable. You can see the stairs going into the basement. You can see the condition of the balance of the structure, and then the exterior, exterior photos of the, showing that there's a deterioration of the porch. We stand by the fact that the structure is condemnable and needs to be rehabbed, and the board can decide on that accordingly.
So you're going to have to get a contractor involved, Mr. Jones.
That's no problem, but I was told by the building department when we went to go pull the permit that we have to get drawings by an architect, and that has to be stamped. I couldn't do the drawings. It has to be by an architect, and that's the biggest issue.
Okay, well, that's not what I'm hearing from Mr. Vanover, but maybe he can.
Can you clarify? Because
Sure.
the building is so commercial has to be stamped by an architect, correct?
Mr. Vanover?
Mr. Chairman, the code does not, unless there is technical analysis included in the plans, then they do not require an architect. It requires architectural quality drawings. They have to be a complete set of drawings where they have to show as required by the building code. But they have to be architectural quality, showing the building systems, showing the floor, and any work that's going to be completed, but they do not, unless there's technical analysis, which I'm not, again, sitting here today, I'm not 100% sure what needs to be replaced and rebuilt. But under the Ohio Building Code, they do not have to be sealed unless there's technical analysis involved. I can't make that ruling here based on, the evidence provided in this hearing. So if there is work that requires technical analysis, if there's structural changes or if there are mechanical system changes as a commercial property, then it is possible. But short of technical analysis, it is not necessary.
So
Mr. Chairman, to Mr. Vanover, just to avoid confusion, does that change at all because it's a 4-dwelling unit structure?
No, sir.
Okay.
Okay, so let's see. We can give you time to bring it out of condemnation. So you're going to need your contractor to go back to the city and with, again, architectural style drawings, okay? And showing what you're gonna be doing and if permits need to be pulled to take care of all that. So we can give you time to do that. Let's say we give you 60 days to get that prepared and underway. And that would be till July 21st, 2024, and November 21st, 2024, 180 days to complete the violations. Motion?
Mr. Chairman, before we take a motion,
Yes.
should the home needs to be vacated, correct?
Well, we're hearing that that's supposed to take place within a few days, I
But
think.
I think that should be part of the motion, that no one is living there until this is brought back into compliance.
I don't think there is a vacate order. Yes, there is. Okay, so
Mr. Chairman, before you make a ruling, just for clarification purposes, there are two different docket numbers and 3 different violation notices.
Four.
Okay, I did not hear the exterior maintenance violation notice addressed. That's docket number 81024.
okay, we're gonna make that as a part of the whole condemnation for the structure. There is one that was named out that the city wanted to uphold the violation as properly issued and to remand that part back to the city for any further action. But we'll consider the rest of the structure as part of the condemnation, and that all of that needs to be taken care of as this, for a solution to move forward.
Mr. Chairman,
Yes.
if I may be able to help. So there's actually multiple violation notices that have been issued and have been closed as part of, once the property was condemned. So I read the number for the vacate order into the record, the notice of condemnation, that notice of violation number is V24006622. And at this time, those 2 violation notices are the only violations opened. The previous violations have been closed when they were closed internally when the condemnation was issued. So there are only 2 active violations at this time.
Okay. So again, we do have that motion out there. Is there any other questions? So we're given 60 days to put that plan together. And that's July 21st, 2024, and to November 21st, 2024, 180 days to abate the violation and bring it out of condemnation. Motion?
So moved.
Second.
Moved by Mr. Dank, second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, the notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next is the housing docket A 401-23, 1204 East 173rd Street, and that docket has been withdrawn. So we'll call the next docket, housing docket A 403-23, 2872 West 32nd Street.
Application and fees are in order. Notice of violation is condemnation of the shed and condemnation of the main structure. Issued on November 15th of 2023. Appeal was received December 18th of 2023, requesting for time to abate the violations. Present for the hearing is Tom Vanover, Chief Billing Official, Dan Jacobson Law. With the appellant or his or her attorney or representative, please state your name for the record. Mr. Chairman,
Okay,
does not look like Mr. Tomorrow is present today.
okay. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
Through the chair to Mr. Jacobson, no.
And through the chairman to Ms. Davis, have you received any form of communication, an email, a voice message, or anything physically delivered to you on behalf of this appellant and or docket?
Through the chair to Mr. Jacobson, no.
To the chairman, the due process requirement of notice having been given to this appellant, the board can proceed with its hearing and ruling today. Thank you.
Okay, thank you. Mr. Vanover.
So, Mr. Chairman, this structure was condemned and a CBO emergency demolition order was issued. The order was issued on, bear with me as I look through my records, the issue date for the order was 11/15/2023. And then the property was summarily demolished. After that, this appeal, I believe, was filed on December 18th, which was beyond the 30-day appeal period. So we would argue, preliminarily, we would argue that it's not a timely appeal. And second, we would argue that as an emergency demolition, that we acted as required and as allowed under our rights for an emergency situation. It doesn't appear that we have photos of the fire itself in the presentation. However, I know Mr. Jacobson has files present in person, or has photographs in person.
Okay.
And it could be provided. The board, this structure was burnt out and burnt to the, was gone. It was a small single story wood frame structure that was burnt to the point of it was just practically gone.
Mr. Chairman,
Yes.
for the record, the appellant was down to file in a timely manner. I have an email that was sent out to Chief Official Tom Vanover as well as Chief Dave Roberts. At the time, the appellant needed an interpreter to help fill out the application and understand what the processes was to put apartments and filed an appeal. So the appeal, they were down here in a timely manner to file the appeal. We just had to get interpreter involved for that process to take place.
Okay. All right.
Okay, Mr. Chairman to Ms. Davis, for the record, do you know the date that the appellant came down the first time?
The attorney reached out to me on December 15th.
Okay.
For that appellant.
So thank you for that, Mr. Chairman. The contract for the demolition of the structure was issued December 11th of 23. We would ask that you uphold the notices properly issued, and then I guess that's all they're appealing.
Okay. Is that notice? That's it? So that was the December 11th?
December 11th, the contract was awarded for the demolition. Again, I state this was a building official emergency order.
Okay.
So I'm not sure what the ask in this appeal is, but we would state that the notice was properly issued, it was properly posted and properly served. on the appellate.
Okay. So, okay, so a motion is that it was properly served with the appellant, and that the issue was December 11th to abate the violation, and it has been abated. So I guess that's our motion, is that it's been abated by the city as a hazard. Motion?
So moved.
Okay, moved by Mr. Maschke,
Second.
second by Mr. Dank.
So, Mr. Chairman, discussion.
Yes,
So the resolution shall state that it was to uphold the notice as property issued, or just that it was abated by the city?
well, both. It was, well, it was December 11th, the order was given, so to abate the violation. Go ahead, Mr. Van.
Mr. Chairman, the order was issued on, the notice of violation was issued on November 15th due to the fire. At which point we contracted the demolition on 12/11. And then they filed the appeal, or came down to attempt to, to start the appeal process on the 15th. So the city had already issued the notice of violation, served the property owner, and had taken possession by contracting the demolition.
Okay,
Under an emergency demolition notice.
yeah, it was, under an emergency demolition notice. So it was December 11th that they acted on it and raised the property, correct?
That's when we contracted it, sir.
You contracted, okay.
I don't have definitive dates on when it was actually raised, but upon the 11th, we had taken possession by issuing the contract. So
Okay.
we would ask that the notice was properly issued and upheld, and then the nuisance was abated by the city.
Okay, so the notice was properly issued and upheld, and the city abated the structure.
Mr. Chairman, sorry, just for clarification, sir, to Mr. Vanover, I've got the appeal over here. Let's just, I know you've done this, so forgive me for repeating this. Can we set out the facts of the case again? So the appeal was made in a timely manner, and this violation notice for November 15, 2023 was to correct, I'm just reading, due to fire damage as set forth herein, this structure shall be effectively adopted pursuant to the codes, or the violation set out below shall be corrected by complete repair. After all requisite plans and specifications have been submitted to the Division of Building and Housing and all permits have been obtained. That, just for clarification, that is the notice of violation that is being appealed, yes?
As far as I know, yes, that's in the appeal, but when you have an emergency situation, I believe all bets are off and the city can abate the nuisance. And I
So,
think that's-
Mr. Chairman, to outline the facts of the case, that is the notice that's being appealed. It's also given a compliance time, and the compliance time on a notice that is an emergency is an immediate compliance time. They are still granted the right to appeal, but the compliance time on this particular notice that was issued on 11/15 of 23, the compliance time is also 11/15 of 23.
Okay, and so nothing was done for it.
Mr. Chairman, if I could clarify, the city's asking that the appeal be denied, that the citations be upheld as properly issued, and that the city acted as soon as administratively possible to abate the nuisances. And we would ask that the matters be denied and remanded back to the Department of Building and Housing.
Okay. So we deny any more time, remand it back to the Department of Building and Housing for any further action. Motion, so in order.
So moved.
Okay, Mr. Maskey,
Second.
second by Mr. Dank.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. I guess notice will be sent out to him within 2 weeks, I guess. Okay, next docket is housing docket A 405-23, 19104 Shawnee Avenue.
Application and fees are in order. Notice of violation is exterior maintenance issued on December 4th of 2023. Appeal was received December 19th, 2023. Appellant is requesting for 6 to 8 months to complete abatement of the violations. Present for today's hearing, Tom Vanover, Chief Billing Official, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
Morning, this is Zach Swan.
Okay, Mr. Swan, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what the plans are.
Okay, so as you can see in the picture, the garage in the top left picture, the garage has been power washed. The doors have been painted. I have the glass in my possession and it's actually going to go in tomorrow. I just needed 2 non-rain days to do it. So there's 2 panes of glass, one that you can see in that upper left picture, and then one on the garage door on the right side. Those 2 panes will be fixed tomorrow, and then 2 of the issues will be fixed. It's just the roof, which is, from what I can tell, is purely cosmetic. There doesn't appear to be any major leaks inside, or really any leaks inside. The tarp was there when I purchased the property, and to my estimation, I believe it was probably put there maybe for an insurance claim at some point. But I do plan on replacing the roof. I just was asking for a little bit more time to do it because I intend to do it myself.
Okay, and this is all on the garage?
Yes, the garage.
Alrighty. Mr. Vanover.
Mr. Chairman, bear with me one moment, please. So Mr. Chairman to Mr. Swan, do you live in this home or intend to live in this home?
I do not live in that home. I do not intend to live in that home, no.
Okay. And Mr. Chairman and Mr. Swan, when did you take possession of the property?
I purchased this property in February of 2022, I believe.
Okay. Mr. Chairman, we don't object to more time, but we would ask for no more than 90 days to make the corrections. This is a, this is a commercial investment property, and and as I've said many times, there's an expectation that property is maintained, especially rental property and commercial property, prior to the citizens of the city of Cleveland having to pay inspectors to go out and find the issues. So we would ask for no more than 90 days to correct all the violations.
I don't disagree. If I could just speak for 1 second, please.
Sure.
I don't disagree with the assessment outside of the time frame, because I do plan on doing the work myself. And being that it is a rental, the garage isn't actively used outside of storage. Nobody is parking a car in there or anything, or going in and out. So it's not so much a safety thing. And actually, I did replace the windows once before, but the glazing didn't hold. So again, it's not a safety issue. It's primarily cosmetic. So, and I do plan to take care of it. I would just like the rest of the summer to do it because it's going to take me a while. But whatever you guys decide is fine.
So, and just in summary, Mr. Chairman, the expectation, even, whether it's a safety issue or cosmetic issue, the decision to do the work, himself is, that's an economic decision.
For sure.
We expect the properties on, Shawnee Avenue in Cleveland to look as good or better than the properties on Ridge Road in Geneva. So we would ask for no more than 90 days.
Okay, motion is in order for August 21st, 90 days, 2024 to abate the violation. Motion?
So moved.
Okay, moved by Mr. Maskey, second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, the notice will be sent out within 2 weeks. Thank you. Next docket, A 411-23, 307 East 149th Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued November 20th of 2023. Appeal was received December 21st of 2023, requesting for 6 months to abate the violations. Present for today's hearing, Tom Vanover, Chief Building Official, Dan Jacobson, Law. Would the appellant or his or her attorney or representative please state your name for the record?
I'm Kara Romano.
Okay, Ms. Romano, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and let us know what your plans are.
So originally we were going to do this work ourselves. But upon speaking with a painter and getting a professional opinion, we're gonna have this painter, Mike Pinter, do it. And so I'm requesting a little bit more time till the end of August to have the painting done, and then the carpentry my husband is working on, which needs to be done before the painting. So so that's the plan. I had sent in some images of my kind of verbal contract with Mr. Pinter. We've booked him for July, August to paint.
Okay, do you live on the property?
Yes.
Okay, all right, Mr. Vanover?
Mr. Chairman, to Ms. Romano, are those shake shingles?
Yeah.
Yes. And Mr. Chairman, to the appellant, do you know when it was painted last?
I do not.
Okay. It's a cute
it's-
house.
I bought the
Mr. Chairman, we don't object to October 1st to abate the violations.
Okay, motion is in order for October 1st, 2024 to abate the violations.
So moved.
Moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket, A 412-23, 3808 East 153rd Street.
Application and fees are in order. Notice of violation is condemnation of the main structure and the garage. Issued on December 20th of 2023. Appeal was received December 28th of 2023, requesting for 6 months to abate the violations. Present for today's hearing, Tom Vanover, Chief Building Official, Dan Jacobson, Law. Would the appellant or his or her attorney or representative please state your name for the record?
Colin Brown.
You can come up to the table, please. Did you hear the name, Mr. Chairman?
Go ahead and say it again.
Colin Boone.
Okay, Mr. Boone, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
Okay, first of all,
it said condemnation, only one room, my house caught on fire in September. He condemned it, never went in the inside of the house. It doesn't even have a garage on there. It's a brand new shed on the property. So I don't know if he's taking a picture of my neighbor's yard, but my yard doesn't have a garage at all. The garage was tore down probably 4 years ago. And the only damage that was really done is to the back of the house. My son's room caught on fire. So I was gonna get, the house is empty right now, but the plan is to put the house back together because I own the house and that's where we were living. But I'm gonna need time. And I didn't want to start putting money into it if the city was gonna take my property.
Oh, I don't think the city wants your property. They'd like you to correct the violation. How much time do you need?
Well, I uploaded some pictures. The fire department really did some damage to the inside. They put a lot of holes in the walls. But I was thinking like, I really wanted a year, but 6 months, that'll work. You know, getting stuff started.
Okay, so you do have an outside shed, but you don't have a garage.
Oh,
correct?
it's a brand new shed. I don't know if
Okay,
I uploaded some pictures, but yeah, it's a brand new, it's an arrow shed. It's brown and beige.
okay. All right, let me go over to Mr. Vanover.
So, Mr. Chairman, to the appellate, just for clarification, you were living in this house at the time of the fire,
Yes,
and the expectation is that you will make the repairs and move back in?
yes.
Mr. Chairman, as the appellant is objecting to the condemnation notice itself and the content of the notice, I would ask that this hearing be postponed for the city to provide a reinspection with a supervisor to look at the property, meet the homeowner on site, so that we can all more accurately discuss the notice itself.
Okay, when can we re-put this docket back on, Ms. Davis?
Mr. Chairman, that's a good question. I will have to look at the present agendas. It probably won't be until December 4th of this year, going off the top of my head.
Okay, well, it sounds like most of it is interior, whatever's wrong, but I guess we'll go ahead and we'll postpone it until that time.
Thank you.
So, Mr. Chairman, to the appellate, I will collect your contact information from Ms. Davis and have the supervisor from, this is in Ward 1, correct?
Oh, repeat that again?
Yes.
This is Ward 1.
Oh, yes, you're in Ward 1, Joe Jones Ward.
Okay.
Okay, so yeah, so I will have the supervisor from that geography reach out to the appellant for a reinspection.
Okay, sounds good. So we won't take any action at this time. So,
Get back in contact with me.
Okay, I got your email address.
Okay, well, send me your, all of your contact information so I can forward it over to Chief Building Official.
Okay,
Okay,
okay.
all right, thank you.
Thank you.
okay, next docket, housing docket A 3-23 15401 Lakeshore Boulevard.
Application and fees are in order. Notice of violation is exterior maintenance. Issued November 29th, 2023. Appeal was received January 8th of 2024, requesting for 6 months to complete abatement of the violations. Present for today's hearing is Tom Vanover, Chief Building Official, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
James D.
Please come up here. Mr. Chairman?
Yes. We go ahead and restate his name.
James D. Ely.
Okay, Yuli. Solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
As of now, everything has been repaired, listed on the notifications with the exception of the painting. The painting would have been done, but of course it's been raining 3 to 4 days a week. The chimney has been tuck pointed, the wood has been repaired, the fascia has been repaired, the gutters have been cleaned.
Okay. So how much more time? do you think-
I
How much-
also have pictures including the repairs.
Okay, how much more time do you think you need?
I would say 2 weeks, but it rains 4 to 5 days a week, so I can't say that.
Okay,
30 days should be sufficient.
okay. Mr. Vanover.
Mr. Chairman, to Mr. Ely, do you live in this home?
Yes, I do.
Mr. Chairman, we don't object to 60 days to get the violations abated and re-inspected.
Okay, motion is in order for July 21st, 60 days, 2024 to abate the violations.
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Maschke.
Question.
Yes,
1 second, we got the
I'm
motion.
sorry.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
yes.
Okay.
Notice will be sent out within 2 weeks. Thank you.
Question.
Yes.
Upon completion, can I notify, I can't think of the inspector's name, Ms. McClure? Can I notify her and have her come inspect it?
That's Mr. Chairman, that's the only way to get it closed. That's what you're supposed to do.
Thank you kindly.
Okay, that's taken care of.
All right, we're good to go.
Thank you.
Okay, next docket, A5-24 17512 Allen Avenue.
Application and fees are in order. Notice of violation is exterior maintenance. Issued on December 14th of 2023. Appeal was received January 12th of 2024, requesting for 120 days to abate the violations. Present for today's hearing, Tom Vanover, Chief Billing Official, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
My name is Robert W. Monroe. I'm the successor trustee of the John W. Hickey Family Trust.
Okay, Mr. Monroe, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
Okay, my plan, I had a sale back in March that unfortunately fell through. And the individual was aware of all the violations and wanted to correct them. I have another sale, signed contract for the sale of the property, but the trust is subject to the overview of the housing court. So I've got to present that offer to the housing court on May 30th at our next status conference. Hopefully it'll get approved and we can finish this up in 90 days.
Okay, Mr. Vanover?
Mr. Chairman, to Mr. Monroe, there was a permit applied for in January to raise the garage. Has that work taken place?
Correct. Actually, the garage was knocked down by a tree from the Metro Parks. And we had actually taken the rest of the garage down. It was pretty much destroyed anyway. But so we were just trying to, take care of the violation after the fact, or pay for the permit rather.
So, Mr. Chairman, to the appellate, there's been no inspections and no closure of that permit.
Okay.
You're required to contact the inspector to have that inspected and to have, and you want the permit closed as compliant.
Okay.
Now, that being said, Mr. Chairman, we object to any more time. This is not a plan to correct. This is a plan to dispose of the property. As we've already stated, there's no guarantee that the new owners are going to make the repairs. The trust has been cited for that. And we would, understanding that the hope is that this property is disposed to a beneficial owner that's going to, correct the violations. However, we ask that until that be satisfied, that we maintain the ability to hold the Hickey Family Trust accountable for the violations. So we would ask that you deny any more time and remand it back to the Department of Building and Housing, as this is not a plan to correct, but a plan to sell.
How about the garage?
Well, the garage, my understanding, Mr. Chairman, is that the garage has been erased. And so once that, and a permit has been issued, and once that is inspected and closed, that will be in compliance. But the balance of the house, we ask that you remand back to the department.
Okay, so for the house, motion is in order to deny more time, remand the property division of Building and Housing for any further action. Motion?
So move.
Moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you. Next docket, housing docket A 924, 3061 West 46th Street.
Application and fees are in order. The notice of violations are as follows. Stop work order, no permit, and exterior maintenance. Issued December 5th of 2023. Appeal was received January 9th of 2024, requesting for time to abate the violations. Present for today's hearing, Tom Vanover, Chief Billing Official, Dan Jacobson, Law. With the attorney or with the appellant or his or her attorney or representative, please state your name for the record.
Sylvester Allison.
Okay, Mr. Allison. Solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, what are your plans?
So I think this is in regards to the foundation. So when we purchased the property, and at the time of the year we purchased the property, there were some holes on the side of the foundation, which I had filled with cinder block because of the weather. So exactly, the picture on the right side of the screen shows the area that I had filled in just to protect the property from the weather, being that it was the winter time. Simply, that's it. So I believe that's the issue. I've submitted permits for the front porch. There are open permits now for the interior work, but I think the issue was the foundation on the right side of the house, the opposite driveway side.
Okay, Mr. Vanover.
So, Mr. Chairman, Mr. Chairman, to the appellate, what is the ask? There's obviously work was completed and began without permits. There are interior permits, but the exterior work was adjudicated. And there's been no response to that adjudication since January. We would ask that you uphold the violation notices as properly issued and deny any more time. You can't work on the property until the permits are properly issued.
Okay, Mr. Allison, you have any response to that?
Well, the concern was that the work that was done on the exterior was simply filling the holes to prevent water and squatters entering the property. Based on the information that was provided to me by the neighbors, that property has had issues for the last few years. So what we did on the exterior was simply fill the holes on the opposite driveway side to prevent water and physical entry. That was it. So that was my thing, not knowing that I needed a permit for that specific task that was taken care of, because I believe the note stated that the complete wall was repaired, which is incorrect.
I'm just looking at the pictures here and, I don't know, that one.
Mr. Chairman, I assert, what is the ask? If the ask is, if the appeal is, to object to the notice, to the violation notice, as issued for work without a permit, I assert that this is work that is required to have a permit. It is work, even if it's just covering. There's a house, the foundation is missing. The house is obviously an advanced condition of decay, and the replacement of that requires a permit. So we would ask that you uphold the violation notice for work without a permit, because it's clearly work that's covered by the Residential Code of Ohio that requires a plan approval and a permit.
Yes.
Okay, Mr. Chairman. So simply all I need is 6 months to get the property to habitable living conditions. I own 20 plus properties. I've just sold 3 this week. So my understanding was that it was expressed that the complete foundation was replaced, which is inaccurate. But 6 months is all I need. Property permits will be pulled for exterior and interior, and that's it.
Mr. Chairman, through the chairman to the appellant, the appeal was filed by From Grounds Up Estate LLC.
Correct.
Mr. Allison, what is your relationship to
I'm a
that?
member of that.
You're a member of
that
that?
entity, correct.
And are you the current owner of the
Yes.
property? Who's
So,
the current owner of the property?
It's under Eric Tong's name, which is my business partner for permit purposes.
Okay. It appears to be, records indicate the property was transferred in February this year from the LLC to Eric.
To Eric, right, exactly.
And I'm not sure how that would relate to pulling permits, or how that would affect the board's decision today.
Mr. Chairman and Mr. Jacobson, can you repeat that? It was transferred from whom to whom?
The records indicate the property was transferred from the LLC known as From Grounds Up Estate LLC to an individual by the name of Eric Tong on the date of 2/21/24. So records indicate there is a new legal owner of the property.
Correct. That's the business partner, Eric Tong, correct.
Is Mr. Tong here today?
No, he's not.
Does Mr. Tong have notice of the violation?
Correct.
And what relationship does Mr. Allison have to Mr. Tom?
That's my business partner. In the operating agreement, it states that Sylvester Allison and Eric Tong own From Grounds Up.
To the chair, Mr. Chairman, we are in possession of an operating agreement that lists both of them as 50-50 partners. You didn't get a copy of this? We'll make sure that you get a copy of it as well. But we do have an operation agreement listing Mr. Eric Tong as well as Sylvester Allison as 50-50 partners.
And this is a rental, correct?
It will be a rental, correct.
Okay. So you said that you needed 180 days to abate the violations totally.
Correct.
And you're gonna pull the permits within 30 days?
Correct.
Okay, so June 21st.
Mr. Chairman?
Yes, sir, Mr. Vanover.
Surprisingly, and we object to any more time. Surprisingly, this property has not been cited for the advanced condition that it is in. So there is not a maintenance or a condemnation or a hazardous condition violation notice issued or before this board. What is before this board is an order to make application for and pull the permits required to do the work and to stop work until those are satisfied. So we don't believe that there needs to be any more time. The appellate has objected to the notice, claiming that it states that the entire foundation has been corrected. The notice states that there's work without a permit. This is regulated work. We don't believe there's any more time needed, and granting more time to the stop work order or to the no permit requirement does not add any value. We would ask that you uphold the notices as properly issued and require that the appellant make application and properly get the permit. I believe the ownership change, based on the information provided, the one permit that actually is in place with an ownership change is no longer, there has to be a transfer process. But we ask that you deny any more time and uphold the notice, because you would only be granting more time to get the permit, which that's already in place, because there's no violation on the property for its condition.
Okay. So we'll uphold the violation notice as properly issued. And when we make this motion, denying more time and remanding it to the property division of building and housing for any further action, you still are able to do everything that you say you're going to do. You just need to go get the permits, do the things you need to do to fix the property. And so that's the motion. So we're upholding the violation and we're denying more time, and we're going to remand the property division of building and housing for any further action. Motion?
So moved.
Moved by Mr. Maskey,
Second.
second by Mr. Denk.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you. Next is a time extension housing docket A 407-23, 567 East 128th Street.
Application and fees are in order. This is a time extension for interior and exterior maintenance. The violation was issued on January 31st of 2023. We received the appeal on December 20th of 2023. We heard this docket on Wednesday, July 19th of 2023, granting the appellant until December 18th of 2023 to complete abatement of the violations. Present for today's hearing, Tom Zanover, Chief Billing Official, Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record?
Odacia Blue.
Okay, Ms. Blue, solemnly swear to tell the truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are. Or, well, I know what your plans are. You're asking for an extension.
Yes. So what happened was we finished literally every violation that has been on the house. The only thing that we have not completed is the work for what the electrical inspector has told us that we needed to do. We were told at one point that we could pull the permit ourselves. My husband does this work for a living, so he was going to fix the things, and then we were told that we needed a licensed and bonded an electrician, that we actually could not do the work, even though that's what my husband told them that we were going to do anyway. We later found out that he could not do the work. Some of the work, shall I say, that was needed to be done through the violations. And so we've been in the ruts of trying to find somebody to be able to do those things. Last week, we finally found somebody who was licensed and bonded. They're expected to pull the permit to be able to do the work either this week or next week. And they are looking to start the work by next Friday. So we kind of have a plan, excuse me, in place. We just need the time to literally just fix the electrical stuff, and that is moving the electrical box to a wall.
Okay, that is what is the last piece that needs to be done, is that correct?
Yes.
Okay, and everything else is completed?
Yes, and Inspector Arnold has come out and okayed all of the other work that has been done. He just told us the things for the electrical inspector we needed to call him for. And when we called the electrical inspector, he said that that is when we were informed that we needed to get a licensed and bonded electrician to do it. And so that's when I said we've found somebody to be able to do it.
And this is a rental property, right?
Yes.
Okay, Mr. Vanover.
All right, so Mr. Chairman, there's been a couple of, I'm looking at the notes, and the permit that has been closed as non-compliant is, permit number E23026643. And that was, inspected by the inspector, and then and that is a homeowner's permit. I do not, so the notice of violation, the last notice of violation has been, unless there's another address, I don't have an open violation notice. So that's not before this board. I apologize, bear with me. So ultimately, there's an electrical permit that was closed non-compliant. If the expectation is that a licensed and bonded electrician is going to take over the work and to pull a new permit, we will issue a new permit. This appeal is moot at that point, because as a contractor, they will need to pull their own permit anyhow.
Yeah.
And we cannot extend this permit to the new electrician.
Got it. Okay. So we just need to get the electrician to just pull his permit next week and we're good to go.
Absolutely.
Okay. I
As
just
far
want
as
to make sure
that's my understanding through the chair.
Okay, so everything else is closed out. There's no action necessary by the board?
Mr. Chairman, we would ask that you uphold the invalid permit letter.
Mr.
issued.
Chairman, discussion.
Yes,
The appellant did not file for a permit being, she came and filed for a time extension on the award that was issued to her on December 18th of 2023 for the interior and exterior maintenance.
Okay.
This is a time extension hearing, not for permit extension.
Okay, so Mr. Chair, so what is that, Mr. Chairman and Ms. Davis, what is the violation number then?
The violation notice for that would be V as in Victor, 230-02884.
As I say, I'm very new to this. Like, this is my first time having to go through this. And so I don't know if I did the thing that I was supposed to do.
You did it. You did it right. On that one, it would have been item 19 for electrical wiring and exposed damage, deteriorated or otherwise unsafe.
Okay.
Underneath that violation notice.
Okay.
so we can simply deny more time for the extension if she's pulling another permit, correct?
Mr. Chairman, bear with me.
Okay.
If you will. So, Mr. Chairman, let me help unpack this a little bit. So there was the notice of violation, and then there was an electrical permit pulled, and then a determination made that the work had to be done by a contractor. With the permit being pulled and being underway, the notice of violation ending in 884 that Ms. Davis read The inspector closed the violation as compliance final. So the violation notice is no longer open. And we would assert that an extension of time is no longer necessary because the notice of violation was closed by the inspector as compliant. But I will caution that that was done with the expectation that the electrical work underway would be wrapped up and finished as well. So while there's no active notice of violation on the property, failure to complete the electrical work will result in another notice of violation. So we would ask that we would not object to the board granting until today for an extension of time on the notice of violation, understanding that the violation notice has already been closed.
Okay,
And then that's the only action the board requires. And then a caution to the property owner to follow through and get the electrician to pull the permit and finish that work so that there's no subsequent notices of violation issued.
okay. Very good.
Does that make sense?
I don't know if I understand that. I don't know what that, I'm sorry, if you can
You're
explain
getting
that.
a permit, or you have a permit already for electrical, and that's the only thing that's, I think, right now that needs to be done. So you're okay. And
Okay.
we're going to okay the violations except for that, the violations to be complete and on today's date, which is 5/22/24.
Okay.
So you're all set. You just make sure that you follow up and complete that permit.
Okay, sounds
Okay, so
good.
motion is in order for today to abate the violation. So moved.
So moved.
Hey, Mr. Dank,
Second.
second by Mr. Bradley.
Discussion?
Go ahead.
Just to clarify, she already has the electrical permit or she needs to get it?
I think she has it. Is that correct?
I pulled one as a homeowner, and then that's when we were told that one would not work. And so now we found, because we needed somebody licensed and bonded, and so we found somebody licensed and bonded, and they're expected to pull the permit either this week or next week to be able to start the work after they pull the official one for them.
Mr. Chairman, in light of that, can we just give her 2 weeks in time? That way there's an overlap to cover her to pull the electrical permit.
Okay, let's redo that motion to give her 2 weeks, which would be June 5th, 2024, to pull the permit for the electrical.
Thank you.
Motion.
So moved.
Okay, moved by Mr. Dank,
Second.
second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you. Bye.
Okay, time extension housing docket A 7-24. And looking at 3235 West 111th Street.
Applications and fees are in order. Notice of violation is condemnation of the garage issued on May 19th of 2023. Appeal was received December 28th of 2023 for the time extension. Okay, we originally heard this docket on September 27th of 2023, granting the appellant until December 27th of 2023 to complete abatement of the violation. Present for today's hearing, Tom Vanover, Chief Billing Official, Dan Jacobson, Law. With the appellant or his or her attorney or representative, please state your name for the record.
Alan Parker.
Okay, Mr. Parker solemnly swear to tell the truth, the whole truth, self of God?
Yes.
Okay, go ahead and let us well, we already know you're looking for an extension, correct?
Yes, I've done quite a bit of work. I removed the patio. I have some pictures here. I removed the patio, painted the entire outside, tarped the top, and painted the entire outside. I was gonna do the inside, but I felt ill the last like 3 weeks. I've been going back and forth to the doctor. But, I'm doing some work to the front of the house. I got $1,200 tied up. In the next couple of weeks, I'm redoing the gutters and the shingles in the front of the house too. That's not part of anything.
Okay, this is a condemnation notice for the garage. Is that complete?
Close. I just need the door, to finish the door and, some of the roof.
All right, let me go over to Mr. Vanover.
Mr. Chairman, yeah, well, the only thing we have, the only notice that we have is the condemnation of the garage. So while I applaud the appellant's work on the rest of the house, what we're here for is the garage. So I just need, what is the ask? How much time are we asking for?
The door and let's see, maybe a couple months.
All right, Mr. Chairman, we don't object to 90 days with no further extensions.
Okay, motion is in order to grant to August 21st, 90 days, 2024, to abate the violation with no further extensions. Motion?
So move.
Moved by Mr. Bradley.
Second.
Okay, second by Mr. Denk.
Thank you.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, okay, notice will be sent out within 2 weeks. We have these series of these bridge dockets I'm gonna give, which has been postponed. I'm gonna give the beginning one and give you the end one, and all those in between will be subsequent to that. So docket A34323 through I catch them all. Through docket A35723 have been postponed. So no action is required on that. So the next order of business is going to be the approval of resolutions. Docket A22623, docket A36023, A36723, 37923, 38423 through 39323, A39523, A39723, and A8124. Motion?
So moved.
Moved by Mr. Maskey. Second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Approval of minutes for May 8th, 2024. Are there any additions or corrections?
No.
Motion?
So move.
Moved by Mr. Bradley.
Second.
Second by Mr. Maskey.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Is there any further business to come before us?
No.
Okay, we are adjourned. Thank you.
Have a good 2 weeks.
Wait 1 second, Mr. Gallagher already left?
Go.
Wait.
That's weird. It's been 1 second.
That's gone.
Yeah, that's. Oh. We just talk about Ashley. Appeal to.
Wait, 1 second, I still have,
Still streaming?
no, I stopped the streaming. I'm putting this one up here.
See. Mr. Gallo. Joy.
Let me,
Casey, very first. They help. Casey, I'm born. Next world. So they have this. Community access.
Mr. Gallagher,
So.
can you come back on?
So Casey said it's like 1 year.
Tom came in, he wants to, have conversations.
Yeah, we do have the option of the Casey asked it and legislative authority.
Okay.
So we went down and it just doesn't make sense, it's one or the other. That was a problem, so I get it does, so. So, which is happening, they want these options, and I did. Which was really interesting, actually, it was really interesting. because the-
Right.
The
Joy, you can log off.
finance person.
We can go?
No,
No, not you, Mr.
Okay.
Bradley.
here he is. Tell him they're back. So the finance lady from the Port Control came in and explained about the Harvard Farm. It was really, it's really interesting, it's educational.
Off.
1 second. Joy,
He will.
No, you're on video.
Oh, wait,
I was saying to get her,
not there, John. What's her name? I don't want to allow me to.
Top.
her.
This is a case, it's not one, it has. Oh.
Yeah. I just.
Yes,
Okay.
yeah.
From the washer.
You verified your stop streaming?
Yes,
You were streaming this morning. So I was frantically trying to get a hold of it.
Okay.
What are
Oh,
we
we're
trying
trying to
to do?
figure out the, what you call it?
It's still streaming,
It says live.
and she's able to stream.
On YouTube?
Yeah.
Wait a minute.
So who are we waiting for?
1 second.
We're waiting to stop streaming. It's Gallagher, we're still streaming.
Homeowners. Get up, wake up and fix this.
There's too much. Yeah, that's